Welcome aboard, applicants. Let's continue part 2 of our October PT. Okay, now in part 1 we laid out our setup. So let's now fill in our setup with our statements that would fill out what would technically be our framework here. Okay, now under first of all, for introductory statement, we want to make sure that we point out to our reader that what it is we're dealing with involves the task that we were given in our LTA 1, number 2, and number 3. When that statement would be included in our introductory statement. Now, in the Ryan is able to disaffirm contract as the minor's power to disaffirm, in underneath the civil Columbia Civil Code here, or excuse me, the Columbia Family Code. Thank you very much. We were going to point out that we're dealing with a minor may make a contract in the same manner as an adult. Okay. Now, remember, we know that they're subject to the power of disaffirmance under that, so we're ... there. Okay, now coming under here now, we would put down a contract of a minor may be disaffirmed by the minor, or maybe disaffirmed by the minor ... before majority or within a reasonable time afterwards. Okay, now then going into Brady now, we want to make sure to bring out what we would bring in terms of Brady. Here's what Brady points out concerning 6701. As a general proposition, a parental consent is required for the provision of services to minors for the simple reason that minors may disaffirm their own contracts to acquire such services. According to Columbia Family Code 6701, a minor may make a contract in the same manner as an adult, subject to the power of disaffirmance, provided by Columbia Family Code 6702. Now, right here, we want to make sure to point that out too. That Brady points out 6701. Oh, sorry, excuse me, 6701. Okay, good. And right here. So, in turn, Columbia Family Code 6702 states that generally a contract of a minor may be disaffirmed by the minor or by the minor's parent or guardian before majority or within a reasonable time afterwards. We got that one down. So we'll make sure that we're noting that Brady dealt with both of these code provisions, that is. Okay, good. Now, the law shields minors from their lack of judgment and experience under certain situations. Under certain conditions, vest them in the right to disaffirm their contracts. Okay, so we want to make sure to bring that out from Brady as well. That the law shields minors from their lack of judgment and experience, and under certain conditions vests in them the right to disaffirm their contracts. Okay, now, although in many instances such disaffirmance may work a hardship upon those who deal with the minor, the right to avoid contracts is conferred by law upon a minor for his protection against his own improvidence and the designs of others. you could say this here, that the right to avoid contracts is conferred by law upon a minor for his protection against his own improvidence, and the designs of others. Okay, and then it is the policy of law to protect the minor against himself and his discretions and immaturity, as well as against the machinations, pardon me for mispronunciation of that, of other people, and to discourage adults from contracting with a minor. So we want to make sure that it's conferred by law upon a minor for his protection, for his own providence. Against the designs of others. We want to make sure to start a little list here, because up here it says it is the policy to protect the minor against himself, against his indiscretions, against his immaturity, and against right here, against the of others, and to discourage, thank you for your patience, adults from contracting with a minor. Okay. Now, slipping down now to 6701 for Janice, we're going to actually borrow this here and point out the fact that we're dealing with Ryan's mom right here. Okay, right up here. Thank you for your patience with me. Right here. Okay. Right here. Maybe disaffirmed by the minor or by, a contract of a minor may be disaffirmed by, not in this situation, not by the minor, but by ... the minor's parent or guardian before majority, or within a reasonable time afterwards. We want to make sure to point out too that, because power to disaffirm. Okay, now exception to the power to disaffirm. This is where we're going to bring in Miller and CFC 6703, which is what we're going to point out right here. A contract otherwise valid, entered into during minority, may not be disaffirmed on that ground if, and we're going to bring this here, the contract is to pay the reasonable value of things necessary for the support of the minor or the minor's children, or the minor's family, and then B, these things have been actually furnished to the minor or to the minor's family, and following up with letter C here. The contract is entered into by the minor when not under the care care of a parent or guardian able to provide for the minors or excuse me, the minor or the minor's family. Okay. Now that's what we would bring up in terms of the issues that we would point out to our reader, gathered from CFC 6703. Now in Miller though, let's jump down to Miller and see what Miller would say right here. Okay, by this action, this is now Bryce. This is up here under the facts of the case. Now, okay, he was entitled. This is Bryce up here. Was entitled to recover all of it unless Family Code Section 6703 stood in the way. Okay, okay. Under that provision, a minor. Okay, so it is. Okay, under CFC 6703, a minor under the care of a parent who is unable to provide for him may contract to pay the reasonable value of things necessary for his support and that of his family, and may not disaffirm such a contract. Now that they're saying, this being true, it must follow that the minor can authorize the use of money held for him for these purposes and cannot recover the money thus paid out. Now, remember down here though, the court in this case in Miller did not find that Josephine expended the money for himself and or Bryce for things necessary for their support, nor could the court have found so, or could have so found. The evidence showed at all relevant times that this Josephine had an independent and substantial source of income. Now, don't see that anything else here. We want to make sure to point out though that four things necessary is brought into our discussion. And remember, necessary for support. Okay. This would probably be something that we could point out as maybe like a sub aspect of this. So, okay. Put that in there like that. We have Miller here. Okay. Now, actual authority. Okay, now we're going down to the authority aspect from 3801. Right here. Actual authority. Okay, A to C is the fiduciary. Okay, that's sorry, 3800. So 3801. An agent acts with actual authority when at the time of taking action that has legal consequences for the principal, the agent reasonably believes, in accordance with the principles manifestations to the agent that the principal wishes the agent so to act. Okay, now that's, and remember now we want to combine that though with 3803, which is going to say at what point the actual authority is created. Actual authority is created by principles manifestation to the agent that, as reasonably understood by the agent, expresses the principles assent that the agent take action on the principal's behalf. And what effect does this have? That's where the Columbia Civil Code kicks in 3810 right here. Any act of an agent within the scope of his or her actual authority binds the principal. Okay. Now that's for actual authority. Let's come down here and talk about now in terms of Laredo concerning actual authority. Let's come down to Laredo. Thank you for your patience. Okay, right here. Okay, under Columbia law, the actual authority exists when at the time of taking action, the legal consequence principle of the we already know this. We already put that down. Now, okay, okay, so I think at this point we could literally combine Laredo to that. Say that Laredo cited this as well. Okay. Now come up here to apparent authority. Let's come up. Actually, let's make sure too that did Laredo cite this almost exactly. Looks like they did. So yeah, so we want to point that out for both 3101 or 3801 and 3802. Okay, coming back up to 3802 though. Okay. Okay. An agent acts with okay, let's see here. Sorry, apparent authority, excuse me. Thank you very much for your patience. Apparent authority is the power held by an agent or other actor to affect a principal's legal relations with third parties when a third party reasonably believes the actor has authority to act on behalf of the principal, and that belief is traceable to the principal's manifestations. Okay, now coming down to 3804, when is this created? Apparent authority is created by a person's manifestation that another has authority to act with legal consequences for the person who makes the manifestation. When is that? When a third party reasonably believes the actor to be authorized and the belief is traceable to the manifestation. Okay, and we want to make sure to copy this here. Oh, thank you for your patience here. Oh, copy, there it is, okay. Actual there it is. Apparent authority. Okay. Make sure to put Laredo right at the tail end of that, and we should have it. Wait a minute. I think it's. Excuse me. Thank you for your patience there. That we should actually put that. Not there. We should put that on 3802. Okay. All right. I think that's good for part one right now. We have everything that we need to start our discussion. Okay. Thank you so much. I'm glad we can practice our performance skills together. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Thank you for tuning in, and God bless.